All rise for the Chief Justice. The Senate is now in session.
Thank you. Please be seated. Thank you all for being present. Can you hear me? I'm honored to be asked to preside at this impeachment trial. I'm honored also my many judge colleagues in the audience, even one that is higher than I was. Judge Bilby is here. The only thing I can claim is a little more experience in the field than any of them have had. However, my previous experience in the impeachment was a small matter compared to what will happen today. I was only involved with the impeachment of a governor, and there were only small issues involved compared to what the issues are today. Today we will be involved in the impeachment trial of President Lincoln, and the charges are grave, and as you've been told, you will each be members of the Senate for the purpose of this, and I only had 30 members before. We have close to 200 members of this Senate. As your program announces, we really at this point are in the last day of the impeachment trial of President of the United States, Abraham Lincoln. We have previously heard fact witnesses present evidence before the Senate relevant to the charges brought by the House of Representatives in the 4 articles of impeachment. In accordance with the rules adopted by the Senate for this trial, both the prosecution and the defense today will present summary witnesses. Thereafter, the prosecution and defense will present closing arguments, following which the members of this Senate, will vote on the 4 articles of impeachment. Are the parties ready to proceed?
Defense is ready, Your Honor.
We are ready for the government, Your Honor.
I will now ask the Senate to stand and raise your right hands, and I will administer the oath to you. We do have a couple of recalcitrant people here. My wife and the wife of one of the witnesses feel that it would be improper for them to vote, so they are not taking the oath with you. That doesn't mean that they are siding with one side or the other. All right, I will say the oath, and then at the end, if you agree, you will say, "I do." Do you and each of you, as senators, solemnly swear or affirm that you will well and truly try the impeachment case involving Abraham Lincoln, the President of the United States, and return true verdicts on the 4 charges against him in accordance with the law and the evidence? If so, say, "I do."
I do.
Thank you. You may be seated. All right, you may call your witnesses.
Mr. Chief Justice, the government calls as its final summary witness in these proceedings Professor Mark Neely.
Professor Neely, if you will take the stand right here, please. And as you have already been sworn, we will not need to swear you again. Thank you, sir.
Would you please, for the record, give us your name again?
My name is Mark Neely, and I'm a professor of history at St. Louis University.
In connection with this proceeding, have you undertaken an investigation?
Yes, I have. What I've done is to examine about 14,000 records of civilians arrested by military authority during the Civil War, the records that are in the government's archives in Washington mostly. These include records of interrogation of political prisoners by the judge advocate. I've studied the president's orders and proclamations suspending the privilege of the writ of habeus corpus. I've held some of them in my hand. I have, in the case of those prisoners who were tried by military commission, essentially court-martials for civilians, I have gone into the court-martial records, and as far as I know, in many cases, the first person since the trial to unfold the bundle of papers, take the red ribbon off, and read the transcripts of those trials.
Do you feel that you've read a representative sampling, then, of the arrest records that may be pertinent to this proceeding?
Yes, I do. And what I I think for us, best to understand what has occurred during the war is to go back to the beginnings and the origins of this policy. And I think for us properly to understand it, we need to forget one thing that we all know. It's, in fact, something that is emblazoned on our national memories already, but for the moment, we need to forget it. And that is that 11 southern states, and 11 states only, seceded from the Union in an attempt to form the Confederate States of America. Now, we know that. We know all those states. They have a distinct cultural and political identity to us because of that. But you want to remember that Abraham Lincoln, when he was inaugurated president in March 1861, did not know that. And what he had seen was a brief wave of secession that began with South Carolina on December 20th, 1860, and ended with Texas on February 1st, 1861. He'd seen 7 states leave the Union, and only 7, or attempt to leave the Union, and only 7 states. At that point, more slave states are still with the North than against it. That is 8. And it is his prime task, he thinks, to get as many of those border states on his side as possible, or keep him on his side. Well, with the firing on Fort Sumter, 4 more leave, North Carolina, Virginia, Arkansas, and Tennessee, but that still leaves Missouri, Kentucky, Maryland, and Delaware, and they are critical to the fate of the Union. Everybody knows that a 15-state Confederacy cannot be defeated. The way Lincoln put it was to say that to lose Kentucky is to lose the whole game. So this explains for us what might seem a constitutional anomaly, and that is Lincoln's early and willing, almost eager use of what was an untried and, in the case of the president, doubtful power to suspend the privilege of the writ of habeus corpus. He does it within less than 2 weeks of the fall of Fort Sumter, and he does it because it's a way of keeping the border in the Union. It's a way he is going to hold on to what he has.
Professor Neely, we have a very helpful timeline here that shows that the Lincoln presidency begins in March of 1861, and that the first suspension of the writ of habeas corpus occurred in April of that year. Is that approximately correct?
That's right.
You've studied the various suspensions, and let's focus now on the year 1861. Can you tell us the suspensions that occurred and the reasons given for them?
Well, there are several proclamations and orders suspending the writ of habeas corpus. The earliest ones are the earliest order deals with the area around Washington, which has been isolated by burning of railroad bridges in Baltimore, and gradually spreads through the year up to Maine. And what then has begun as a border policy, something for Maryland, maybe for Kentucky and Missouri, has very quickly spread all over the North, and eventually is suspended in all the northern states in certain kinds of cases.
You said a moment ago that prior to these events in 1861, this had not been done before.
That's right. And Lincoln is naturally uncertain of this power. It's never been used. And so he did ask his Attorney General to provide him an opinion. On April 19th, he asked for it, to provide him an opinion on the President's power to suspend the writ of habeas corpus. The Attorney General asked the Assistant Attorney General, Titian Coffey, to prepare the memo on it. And the memorandum basically said that the President couldn't do it, that it had never been done, but that the known commentaries on the Constitution and the known track record was that this was a congressional power.
So that we have a written opinion from the Law Enforcement Office of the United States saying that the power does not exist in the President.
That's right.
You said that the power was in the Congress. I have placed here on a board, and the members of the Senate have in their materials handheld-sized copies of these. We have Article 1, Section 9. Would you just refresh us by telling us why it is significant that the habeas corpus provision appears in Article 1 of the Constitution?
Article 1, of course, is the part of the Constitution that deals entirely with the powers of Congress, and only with those powers of Congress. So the fact that the clause, although it uses passive voice, appears in there is certain evidence that this is strictly a congressional power.
Did the President take steps to seek in 1861 the approval of the Congress of the United States?
The President did not. He assumed that this was a presidential power, and he invoked it immediately, almost immediately, as you can see on the 27th of April for the first time, and several times thereafter.
There are a couple of significant events that occur shortly after the writ has been suspended, and they're referred to on the timeline here. The first I'd like to ask you about is the arrest of Mr. Merriman in Maryland in May of 1861. Can you tell us what it was that Mr. Merriman was accused of doing?
Well, John Merriman was arrested by federal military authorities in Maryland for drilling troops allegedly to take them south to join the Confederacy, and for aiding and abetting in burning the Baltimore bridges. His lawyer sought a writ of habeas corpus to release him from the Chief Justice of the United States Supreme Court, Roger B. Taney. Taney, sitting in the Baltimore District Court, gave the opinion in the case, which was that the President had no power to suspend the writ of habeas corpus and that this was an unconstitutional arrest.
This was an opinion by Chief Justice Taney.
Yes.
And was the President of the United States, Abraham Lincoln, made aware of that opinion?
Well, he wasn't present in the courtroom, of course, but Taney very much wanted Lincoln to know about this, and so he took care and wrote in the opinion itself that he was providing for a copy of this to be sent to the President so that he could take care in reading it that the laws be upheld.
Did he, in his opinion, then remind the President of the United States of his duty under Article 2, Section 3 of the Constitution?
Yes, he did remind him that the President shall take care that the laws be faithfully executed. Lincoln received the opinion and answers it in veiled language, not specifically mentioning it, in his July 4th special message to Congress.
And what does he say?
He thinks that although the Constitution says that the privilege of the writ of habeas corpus cannot be suspended except during rebellion and invasion, that it doesn't say who, and that in an emergency the President could.
The next matter that I'd like to briefly talk with you about is a matter involving the Maryland legislature. Are you familiar with that matter?
Yes, I am.
This also occurred in 1861?
Yes.
Could you tell us about it?
And it was an event in which federal troops arrested some 16 members of the Maryland State Legislature on their way to open the legislature. It was feared that they were going to vote to take Maryland out of the Union, to secede along with the other Confederate states. This is part of this general concern in the first 2 years of the war about keeping the border states on the northern side, this was thought to be necessary to prevent the state from seceding.
And did it have the effect of terminating the Maryland State Legislature?
The Maryland did not secede.
Well, I would ask, did the President explain his reasons for taking this action?
Meeting with a delegation from Baltimore while newspaper reporters were present, he explained that he wouldn't have done this except for grave reasons that were related to the rebellion, that he couldn't just now reveal exactly what those were, but that at some future time he would.
And did that future time arise?
Never.
Never explained it?
No.
Let's move forward now to the next year, to 1862, at the time that the the conscription laws were passed, was there a further suspension of the writ of habeas corpus in that year?
Yes, and with very dramatic results. In the last 3 weeks of August and the first week of September, there are literally hundreds of people arrested in the North. And we have an exhibit, I think, that'll help remind us, and it's also in the documents you have at hand.
We have here is a series of examples,
Right.
do we not, of arrests that occurred shortly after the suspension of the writ in August and September of 1862?
And I think you can see from these examples, and these are few among many, that what some important patterns are to recognize. First is that we see them in Illinois, New Hampshire, Pennsylvania, New Jersey, Iowa, Indiana, Pennsylvania. These are not states threatened with invasion by Confederate troops, as Missouri and Kentucky admittedly were. These are not states where there are secession movements or parties. And furthermore, the behavior for which the arrests are made are, in many cases, it's what we would have to say would be ordinarily exercised as freedom of speech or freedom of the press.
Can you give us a couple examples?
Well, I'd like to focus on just the first one. Dr. Israel Blanchard, who was from Lincoln's home state, Illinois, from Jackson County, arrested on an affidavit of a person who alleged that he had attended a meeting of a disloyal organization. Dr. Blanchard was whisked out of Illinois to a military prison in Washington, Old Capitol Prison, and he would have languished there probably longer than he did had he not been the brother-in-law of a very influential politician, John A. Logan. John Logan intervened for his brother-in-law with the president, wrote him a letter explaining that his brother-in-law was not disloyal. And in October, finally, after an August arrest, Lincoln released Dr. Blanchard from prison.
Did President Lincoln at that time indicate that the arrest had been unlawful or improper in the first instance?
No, he didn't.
We have a number of other names of other people here. Do we know whether the president was at least generally aware of the arrests that were occurring in August and September?
Oh, he's generally aware, and there is evidence occasionally of intervening, in this case where he intervenes to release a prisoner, and he is involved in many of these directly, and in fact, one of his orders to suspend the writ of habeas corpus is in the case of an individual. And he writes an order in 1861 to suspend the writ of habeas corpus. He sends it to General Winfield Scott, who's the General-in-Chief of the Armies, to suspend the writ of habeas corpus in the case of a Major Chase, lately of the Engineering Corps of the United States Army. And he signs this order in Major Chase's case. Well, the order does not even provide the first name and middle initials of Major Chase. It is an invitation to wrongful arrest. But the president, to reconstruct the scene, we have to believe that the president, who has authorized the Secretary of State, William H. Seward, to oversee political prisoners, has been presented by Secretary of State Seward with a case of Major Chase. He says, President, you must do something about this. There's an order drafted in somebody else's hand. I've seen this order. And Lincoln takes it and signs it. But it's very carelessly written. And we have here part of the general pattern, and that is in his concern to keep the border and save the Union, he neglects his duty also as a steward of the Constitution.
Professor, you say you've looked at a lot of these arrest records. Would it be accurate to say that while we have 11 examples here, that there were literally hundreds of people arrested?
Yes, and of course those who, like Lewis Bobson, would probably under the influence of drink, go out into the streets in the night in a far northern city and hurrah for Jefferson Davis, They, of course, did not benefit from having a brother-in-law who was an influential politician, as Dr. Blanchard did, and they might remain a long time for small cause.
Mr. Bobson's crime was that, among other things, he called the president, and I'm reluctant to use the words, but a damned fool. For that, he was arrested.
Yes.
He, along with at least, is it 364 other?
Yeah, 354, I think.
354?
Yeah. Mm-hmm.
In that 1 month alone.
Yes.
Now, in these places, you pointed out to us that it occurred all over the North. We have the states where some of these examples occurred. Were the gentlemen in these cases taken before a civil court?
No.
Were the courts sitting?
Yes. The courts in most of these states, of course, have been uninterrupted in their sessions, and these prisoners are not brought before them.
Let's move forward now to 1863. As we know, the Emancipation Proclamation is issued at the beginning of that year. Does there come a time early in the year when Congress does take a position with respect to habeas corpus?
Yes. Congress, of course, dominated by Lincoln's own party, the Republicans, are nevertheless uneasy about a pattern like this, and uneasy about the president's authority to suspend the writ of habeas corpus. So by March 3rd, 1863, Congress passes a law, a Habeas Corpus Act, which authorizes the president to suspend the privilege of the writ of habeas corpus. One of the interesting things about this law is that it doesn't only authorize the president to suspend the writ of habeas corpus, but also provides for certain limitations on his power. And this is, you know, you can tell in part from the clause in the Constitution. After all, the privilege of the writ of habeas corpus may be suspended in cases of invasion or rebellion when the public safety requires it. And so it is not as though, oh, there's an invasion, the writ of habeas corpus is suspended. Oh, there's a rebellion, the writ of habeas corpus is suspended. Instead, the public safety is supposed to be in danger, which it probably was not, certainly was not in Buffalo, New York. And so Congress, concerned about issues like this, puts limitations on the authority to suspend the writ of habeas corpus. And what they require is that the arresting authorities supply the circuit or district judge in the area where the prisoner resides, supply the judge with a list of the names of persons arrested by military authority. If during a term of the court a grand jury meets and does not indict these prisoners, the judge is to release them. If the federal authorities, and Congress provided for this, if the military authorities fail to send the list of names, and 20 days passed, and a grand jury meets and no indictment comes down, then any person, or the prisoner, may apply for release and be released by the judge.
Professor, in the years after the issuance of that legislation by the Congress of the United States, did President Lincoln conform the conduct of the executive branch to the limitations in that statute?
No, the lists were, I looked high and low and I could find only one of these lists applied to a circuit or district judge.
So that with all of the arrests that occurred after 1863 March, the limitations Congress imposed were not followed?
I could not find records of it. And of course, the most important limitation that was not followed was that the real limitation they're looking for here is that these people be given their day in court. And in the case of the arrest, as you can see on the timeline here in May of 1863, yes. The arrest of Clement L. Valandingham in Ohio, we have a case where a political prisoner is made, and his fate is to be tried by a military commission, by essentially a court-martial for a civilian. He is tried in Ohio and sentenced to confinement for the duration of the war. Lincoln commutes his sentence to being banished into Confederate lines. which he thought suitable for someone alleged to be disloyal. The point of the limitations put in the Habeas Corpus Act was that the prisoners should either be released or tried by a civil court since these were prisoners made in states where the ordinary civil courts were in session and had been.
Did there come a time when the president took the opportunity to defend his decision with respect to Mr. Valandingham?
Yes. He responded to a letter complaining about Valandingham's arrest sent to him by Erastus Corning and some other people in a long public letter published widely in the newspapers and such in June of 1863, often called the Corning letter.
We have an excerpt from that letter. Did the president acknowledge that the arrest was inappropriate?
No, he did not. He defended it. I should mention, while we're putting the exhibit in place, that what Clement Valandingham had done was not some clandestine conspiratorial activity in the basement. He'd given a speech in the open air at a political rally in Mount Vernon, Ohio, at which a federal officer was present, took note, essentially a spy, took notes, reported it to the commander of the military district, which resulted in the arrest of Clement Valandingham. And then, eventually, in this, a defense of the arrest, which includes this statement.
Professor, to end your helpful direct examination, would you read for us the excerpt that you thought relevant from this letter?
Arrests are made not so much for what has been done as for what probably would be done. The man who stands by and says nothing when the peril of his government is discussed cannot be misunderstood. If not hindered, he is sure to help the enemy. Much more if he talks ambiguously, talks for his country with buts and ifs and ands. And we can see the direction that the policy has taken and that it is going in this. We have a chilling doctrine here that would make silence, the absence of cheering for the government, culpable cooperation with the country's enemies.
And did arrests continue throughout the remainder of that year and then into the next?
Yes.
Mr. Chief Justice, we have no further questions in direct examination.
Thank you, Your Honor. Professor Neely, you're familiar with the War Powers Clause in the Constitution, are you not?
Yes.
Talk about the habeas corpus clause. It doesn't specify who shall exercise it, does it?
No, it does not.
It simply defines the circumstances under which the suspension of the writ of habeas corpus is permissible,
Well,
right?
that is, the sentence itself does not specify. Of course,
That's
its
right.
placement in the Constitution is significant.
That's right. But the language of that clause in Article 1, Section 9 is that the writ shall not be suspended, right?
Except in cases of rebellion
That's
or
right.
invasion.
With
when the
no
public safety
reference
requires.
to who or whom or what can suspend it, right?
Not in that sentence.
All right. In fact, the law at the time was quite unclear, wasn't it? What little there was.
What little there was rather unclear. There was very little of it since it had never been invoked.
Right. There was some oblique reference to it in Story's commentaries
Yes.
30 or 40 years earlier,
Yes.
right? But the only case was the Merriman case, right?
Yes.
In 1861.
Right.
In that case, Justice Tawney was sitting as a district court judge, correct?
Well, no, that's not correct. He was sitting in a district court.
That's right.
But the lawyer for Merriman first sought Tawney in his office in Washington, in chambers.
But the fact remains that Justice Tawney was riding circuit, as we say, when he heard this matter.
No,
Isn't that true?
actually he wasn't. Tawney, excuse me, Tawney took the case because the Supreme Court justices have direct jurisdiction in habeas corpus cases under the 1789 Judiciary Act. And so he is taking direct jurisdiction as a Supreme Court justice in chambers. He chooses to hear it in the Baltimore court and to render his decision there so that the military officer holding the prisoner will not have to leave his military jurisdiction, he said, as a convenience to that officer.
I guess my point is it was Justice Tawney and no one else, right?
Well, that is true. It was only Justice Tawney.
And there was no appeal from that decision, was there?
No, there was not.
All right. So we can't consider that some sort of precedent from the Supreme Court, can we?
Well, we can consider it a precedent from the Chief Justice of the Supreme Court. It was a question
That's
what
1 out of 9. Is my math correct?
Right.
All right. And Professor Neely, that's the same Roger Tawney, by the way, who wrote the Dred Scott decision? The same one?
It is the same.
All right.
Chief Justice.
That is about the extent of any guidance President Lincoln had in 1861 when the suspensions first occurred.
Well,
Isn't that true?
he does have a memo that he has sought from the Attorney General's
Judicial
office,
guidance,
which
sir.
suggests that it's a congressional power.
No. Judicial guidance, that's it.
Oh, okay. Only judicial guidance.
Well, let's talk about the suspensions between April 27, 61 and March 3rd, 1963. There are approximately 7, right?
Okay, yes.
Ballpark. Now, either those suspensions occurred from a direct order of the president, but more commonly they were done by subordinates, right?
He does often delegate the power to suspend the writ to military officers.
And in fact, that's usually what was done, right? Most of the time.
He is aware of what is happening.
And those suspensions are publicly known.
Yes, they are.
And until Congress acts, almost 2 years passes from the first suspension to when Congress enacts its own suspension, correct?
Yes, that's true.
Professor Neely, during those 2 years, during all those suspensions, did Congress ever protest?
Well, I think...
Did Congress ever enact legislation repealing the president's purported
no,
suspension?
they didn't. But what Congress
Did they
is...
ever propose legislation?
Congress is an organization that consists of Republicans and Democrats.
I'm aware
It is
of that,
dominated, It is dominated by Republicans who naturally are not eager to question the authority of their Republican president.
Ah. So I guess the question is they didn't.
Until March
right?
1863, when even they...
When they acted on their own, right?
On their own.
That's something else. On January 1st, 1963, the president gave his Emancipation Proclamation, correct?
Yes.
Did Congress ever claim that that proclamation, issued under the president's war powers, correct, somehow invaded the legislative prerogative of Congress?
No.
Congress could have legislated the end of slavery, could it not?
Well, since slavery is mentioned not by name, but several times in the Constitution, it was widely thought they could not.
Well, in any event, suspending slavery, terminating slavery through a presidential proclamation is nothing that is there in the war powers or anywhere in Article 1, is it?
Oh, no, it's not.
But Congress liked that presidential act, correct?
Yes.
So they
The
didn't
Republicans in
protest.
Congress did.
Congress didn't protest. Congress had no contrary legislation. The matters stood as they stood, right?
Yes.
All right. Let's talk about that March 3rd, 1863 statute. The one when Congress itself suspended the writ of habeas corpus. By the way, Congress suspended it nationwide, right?
Yes.
For any reason. For any reason. If there's some doubt in your mind, you might want to look at the statute, sir. Is there any limitation on the purpose of suspension in Congress's act on March 3rd, 1863?
Any limit on the purpose of suspension?
Yes.
No limit on the purpose
It's
of
without
suspension.
limitation,
That
isn't
I
it, sir?
understand.
Yes. Now, when Congress passed that act, was there anything in that legislation which said they disapproved of the president's earlier suspensions?
No, but nothing in it said they approved of it either.
Right. It's silent, right? And in fact, Lincoln, when he made the first suspension himself back in April of '61, made it very clear that he was suspending the writ of habeus corpus on behalf of Congress. Isn't that right?
You mean not in the proclamation itself?
Well, that's what he explained afterwards in a special message to Congress about 2 months later, right?
He explained that it seemed that the president should be
Yes.
able to act since Congress wasn't in session.
And in fact, he did it because Congress wasn't in session. There was a dire military and political emergency, right?
An explanation that works better for some suspensions than
Yes.
others, depending whether Congress is in session.
But he also expressed confidence that when Congress finally came back in session, it would ratify his conduct.
He did.
Didn't it?
Yes.
Okay.
And
Once
he had
again,
good reason to, since he knew that with the departure of the Democrats, with the large number of Democrats with the Southern Rebellion,
Yes.
that he could count on the Republicans to ratify.
the fact of the matter is, sir, that during that 2-year period, Congress did nothing by way of enactment to show disapproval with the president's earlier suspensions. Isn't that right?
That is true.
And in fact, the March 3rd, 1863 suspension broadened it, right?
Also limited and made clear what the
As
limitations
to
on it should be.
procedure, but as to what it covered and the geographical territory, it was throughout the country, wasn't it?
Yes.
Dr. Foner, Dr. Neely, excuse me, let me ask just the last couple questions. The war's over, right?
Yep.
The North won. Lincoln, as commander-in-chief, was successful, right?
As Commander-in-Chief, yes.
Yes. Consider him a hero for doing so?
Certainly.
You think history will record him as a hero?
I think history will record him as a very successful commander-in-chief
I see.
and as a failed steward of the Constitution.
All right. Nothing further, Your Honor.
Thank you. You may step down, Professor. The defense may call its witness.
Yes, Your Honor. On behalf of the President, we call Professor Eric Foner. That's it. Dr. Foner, you're a professor of history at Columbia University,
That's right.
and like Professor Neely, you've also studied the Civil War period and Lincoln's conduct during that war.
Yes.
Dr. Foner, let's start off with the military situation that President Lincoln was confronted with on March 3rd, 1861, when he became president. What was the military and also the political situation he faced?
March 4th, of course, but the situation was very dire. He faced the greatest political and military crisis in the history of the country. As we heard, 7 states had seceded from the Union and declared that they were no longer parts of it. There was grave danger of Washington, D.C. being cut off. There was danger of Maryland seceding. And, you know, he faced an unprecedented political crisis, and one that I think the Founding Fathers had never imagined in their wildest dreams might happen.
How about militarily? What was the immediate military situation facing him that day?
Well, the regular army was tiny. As I said, there were bridges, as we know, being burned in Maryland, or shortly would be. There would soon be riots in Baltimore to prevent federal northern troops coming down to defend the capital. And there was great fear of an invasion of Washington, D.C. by Southern forces.
Okay. Let's turn specifically to the date of April 27th, 1861, the first day that President Lincoln suspended the writ of habeus corpus in the absence of a Senate not in session. What was the specific problem militarily he was dealing with on that day?
The specific problem was the isolation of Washington and the difficulty of getting troops through on the rail line from Baltimore to, from the north through Baltimore to Washington.
That was the so-called military line.
The military line. There were riots in Baltimore. The first bloodshed of the Civil War were soldiers killed in Baltimore trying to get to Washington. Bridges, as we heard, were being burned, and there was grave danger that Maryland would, Washington would be completely cut off from the rest of the country.
When the president suspended the writ of habeas corpus on behalf of Congress the first time, what authority was he relying on to do so?
Well, one would assume he was relying on the war power of the president and his role as commander-in-chief and the clause of the Constitution stating that in an emergency, in a rebellion, invasion, public safety, he had the writ could be suspended.
Did it succeed?
Well, it appears so, yes. Troops did get to Washington, the bridge burning stopped, and the capital was defended.
Okay. Absent that, was there a significant real risk that Washington would have been surrounded and fallen in the early days of the war?
Well, many military leaders felt that that was the case. The Union Army, as was shown when it finally did get into battle, was woefully unprepared anyway, and the Southern Army was in much better shape, really, so there was grave danger that Washington could fall.
Let's talk about the other suspensions between April 27, 1863, and the date in March when Congress finally acted.
Well, there were quite a few suspensions, and for very specific reasons. The thing Well, the thing we have to remember, Professor Neely reminded us correctly, we have to, in a sense, forget what we know happened. On the other hand, we must also forget that we know that the North won the war. But looking back, it's easy to say it was inevitable and there was really no military problem, but during the first couple of years of the war, and even into 1864, the Union was losing far more battles than it was winning, and certainly in 1861-62, the military situation was very dire throughout that period, and battle after battle was being lost, and you know, there would seem to be grave danger of the failure of the war effort.
Mm-hmm. Since these 4 articles of impeachment all address the president's suspension of the war and things of the writ of habeas corpus and things that flowed from it, let's focus on that. Each of those approximately 7 times President Lincoln suspended the writ. Did Congress complain?
Never.
Was there any organized congressional opposition?
No.
Were there any
a few Democrats complained, but the large Republican majority did not.
Were there any bills proposed in either house of Congress attempting to undo the president's suspension?
I'm not sure if any were proposed, but certainly nothing was ever passed which in any way undid them.
All right. Were there any Supreme Court cases holding the president could not exercise the suspension of the writ on behalf of Congress in Congress's absence?
No, such case never got to the Supreme Court during the Civil War.
Okay. Were there any Supreme Court cases suggesting that the president, under his war powers as commander-in-chief, did not have authority to suspend the writ on behalf of Congress?
No, there were no such cases.
Let's talk about that March 3rd, 1863 statute. Compared to the breadth and application of the president's earlier suspensions, how broad was Congress's suspension in 1863?
Well, it was broader in that it covered the entire country, and it did not list any particular reasons why the writ of habeas corpus would have to be suspended.
Was it directed to any particular persons?
No.
Any particular places?
No.
Any particular reasons?
No, no, it was broad and universal.
Would it be possible for Congress to have enacted a broader suspension of the writ of habeas corpus than they did on March 3rd, 1863?
I'm sure they could contrive some way, but it would be difficult.
All right. Yeah. Now, Mr. Valandingham, that the prosecution raises, was arrested when?
In March 1863.
Or how about
Or
May
was it
1st?
May 1863, right.
All right.
Spring of 1863.
I guess the point is that Mr. Valandingham was arrested after Congress enacted its own suspension of the writ of habeus corpus. Is that correct?
That's right. It's also worth noting that at the time that he was arrested, there was a real danger of the invasion of Ohio. We know in retrospect it didn't happen, but this was just before Lee was moving his army into Pennsylvania, and there was supposed to be another thrust in the west into Ohio. Cincinnati was barricading itself. So Ohio was, in a sense, now in the theater of the war in a way it had not been.
Right. With the advantage of hindsight, the risk was not as large as it seemed then.
People were very nervous in Ohio in May of 1863.
Okay. We've talked about the military progress of the first 2 years, Dr. Foner. Let's talk about things changing in the summer of '63. What happened to change this, what you called a desperate military situation?
Well, looking back, we know that the Battle of Gettysburg, the fall of Vicksburg in July 1863 marked the turning point of the Civil War, and the Union's prospects became much brighter at that point, although in '64 they dimmed again for a while.
Okay. Once the military situation became brighter, let's talk about what happened politically. In 1864, what happened that has a bearing on all these facts?
A certain number of Republicans tried to dump Lincoln, really, as a candidate
Why?
for re-election, and put forward John C. Fremont as a candidate. Why? Because they felt Lincoln was not prosecuting the war vigorously enough, and that they thought that they were thinking that his policies on Reconstruction would not be to their liking.
He wasn't tough enough?
They thought he wasn't tough enough. More vigorous, aggressive leadership was needed, yes.
And they tried to dump him.
Right. They nominated an alternative candidate to run as the Republican candidate, Fremont.
That was a professional military officer, is that right?
Yes, he was an officer of the Army, yes.
And what happened to that attempt?
Well, it did not succeed. The bulk of the Republican Party renominated Lincoln, and Fremont eventually withdrew from the race.
Although it's only been a few months, Dr. Foner, let's talk about what is on the political horizon in Congress now. What's the main issue this country faces?
With the end of the war, the issue that has come to the fore is what we call Reconstruction. That is how the nation will be brought back together, what the status of the former slaves will be, what punishment, if any, will be meted out to the rebels and leaders of the Confederacy, etc.
And does President Lincoln appear to see eye to eye with Congress, or are there differences of opinion on how to proceed?
There are many in Congress who do not approve of the course that President Lincoln seems to be outlining, and indeed in 1864, Congress passed its own plan of Reconstruction, the Wade-Davis bill, which President Lincoln pocket vetoed, and that was an indication that there were some fairly serious differences between Congress and the President over Reconstruction.
Dr. Foner, I have 2 or 3 more questions. The attempt to dump Lincoln in 1864 politically, how did that end?
Well, it did not succeed, of course. Lincoln was renominated and reelected.
It's a failure.
Right.
This recent unfortunate attempt on the president's life by one Mr. Booth, how did that end?
Fortunately, it did not succeed.
That was a failure.
Yes.
And now we're here facing this impeachment attempt.
Yes, and of course, if the president is removed by the Senate, then Vice President Andrew Johnson will become president, and many in Congress feel that Johnson is more radical on Reconstruction than Lincoln would be. As military governor of Tennessee, he committed acts far in excess of anything that has been mentioned in this trial. And he has said publicly traitors must be punished, treason must be made odious. He has indicated he wants to deprive the leading planters of much of their property. And certainly there are those in Congress who think that would be the direction to go in reconstructing the Union.
And in the end, it's all about politics, huh?
That's one way of looking at it.
Okay. Thank you, Dr. Foner.
You may cross-examine.
Professor Foner, fair for us to conclude, based upon your last remark, that you see this as a political prosecution?
Yes, I do.
You do not accept, I take it then, the proposition that there may be merit to the claims that the President engaged in the commission of high crimes and misdemeanors?
That's right.
You find no substance in the accusations that his conduct was in direct violation of the Constitution?
That's right. I think that some of his subordinates were overzealous at times, but it's hard to believe that the President, while conducting the war, had an obligation to oversee every single action of every colonel and major in the Union Army. And as we heard, in some cases, when they went beyond the bounds of what was necessary, he reversed those orders.
You do not dispute, do you, sir, that it was the President who was responsible for the decision that we talked about this evening to suspend the writ of habeus corpus in 1861 and 1862?
I don't dispute that he was generally responsible. I don't think he was responsible for every single arrest that was made, because, as we heard, there were quite a few of them.
Are you able to point to a single case in which the President said that an arrest undertaken pursuant to any suspension of the writ was unlawful?
No, but he did, as we heard, release some people, and it's quite, I think it's unlikely that he knew of every single arrest as it was being made.
Do you have any doubt that he knew of many arrests?
I'm sure he did.
Do you have any doubt that he knew of most of the arrests?
Well, I don't know if he knew of most. He certainly knew of many. He also knew that the writ of habeas corpus, especially in 1862, after the passage of the Militia Conscription Act, that Democratic judges were releasing men from the Army on writs of habeas corpus, and that it was a serious military problem in many parts of the North that the writ of habeas corpus was being used to undermine recruitment into the Army.
You don't have any doubt, do you, sir, that the President well knew that men were being arrested either for conscription violations or for speech-related activity without presentment of cases to grand juries?
Well, that's what it means to suspend the writ of habeas corpus, isn't it? So, yeah, of course he knew that.
Do you think it does mean that cases need not be presented to grand juries?
Well, I'm not a lawyer, but as I understand it, it means that you can hold someone without charge if you suspend the writ of habeas corpus.
In 1863, when Congress authorized suspension of the privilege of the writ of habeas corpus, is it correct, as we were told earlier by Professor Neely, that limitations were imposed on the acts that would occur after suspension?
Professor Neely knows the law very well, so I have no doubt whatsoever that that's true.
And one of those provisions was that when someone was arrested, his name would be forwarded to lawful authorities in the judiciary so that the matter could be presented to whom, sir?
To grand juries.
To a grand jury.
Yes.
Do you dispute that, in fact, the President of the United States routinely ignored that requirement?
I don't know how many cases there were after that, but I'm sure that it's right, if Professor Neely testified to it, that happened.
Okay. You based, if I heard you correctly, some of your conclusions on the presumption that the Constitution was not written by people who had this kind of conflagration in mind.
Well, I don't think that the Founding Fathers expected 11 states to levy war against the rest of the states. I can't imagine that they imagined that was possible, but perhaps they did.
Did they imagine that it was possible that there would be wars in the future in the United States?
Of course.
Indeed, they accounted for that in a number of places throughout the Constitution, did they not?
Yes.
Indeed, the war powers provisions relate directly to the expectation that we might have wars.
Yes.
Fair to say that the founders had just come through a war. The war was very fresh in their minds.
Yes, it was.
Indeed, among other examples, in the very amendment to the Constitution that deals with presenting cases to the grand juries, the Founding Fathers dealt with the question of war, did they not?
Yes.
The Fifth Amendment says no person shall be held for capital or otherwise infamous crime unless on a presentment or indictment to a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger.
That's right.
These are words written by people who expected that there would be wars and that there would be a need for accommodation in warfare.
Yes, but I don't think they expected a civil war, which creates a rather different kind of military political situation than a war against a foreign power.
You don't disagree that it is in fact true that President Lincoln, pursuant to a specific provision of the Constitution, requested an opinion in writing from the Attorney General's office?
I know that that's true, yes.
And he received an opinion.
Yes.
And the opinion said that he did not have the power unilaterally to suspend.
That's right.
You don't dispute that Chief Justice Taney wrote an opinion coming to precisely the same conclusion.
That's right.
You don't dispute that Chief Justice Taney sent that opinion to the President, acknowledging that he, as a justice, had no power to remove Mr. Merriman from Fort McHenry, but that the President did.
That's right.
And that the President should be mindful of his duty faithfully to take care that the laws be executed.
That's right. But I don't think the President considered that a definitive ruling by the entire Supreme Court on the matter.
You would agree with me, I take it, that if a president, hypothetically, were to engage in an obstruction of justice, that would be an impeachable offense.
I can't imagine any president doing such a thing.
And specifically, if a president were to interfere with a juror or with a jury, that too would be an obstruction.
I don't know. It would really be the job of the, as you well know, the Constitution is rather vague as to what high crimes and misdemeanors justify impeachment, and it's up to the House of Representatives and the Senate to decide that.
Do you think that if a president were to take a step to encourage someone to be deprived of a lawyer, a right given under the Constitution in a criminal trial, that would be an obstruction of justice and might be a high crime or misdemeanor?
It might very well, but I'm sure that the Congress would judge the circumstances under which these acts took place. And if in the middle of a civil war, acts that seem completely outrageous in peacetime might be judged by Congress to be legitimate, to be justified.
Which leads me to my final question. You seem to place great reliance on the absence of opposition from the Congress of the United States. Is it your position that the failure of Congress to intercede in some way ratifies President Lincoln's conduct?
Not necessarily, but I think it does make one wonder why now Congress is declaring these acts worthy of impeachment, whereas when they took place, Congress never said a word about them.
Would it be equally fair to say that when Congress raised no hand in 1861, 1862, and 1863, it might have been because they were dominated by his political allies at that time?
It's very possible. Nonetheless, they are the Congress, and there are still many political allies in Congress, I would assume.
I have no further questions, Mr. Chief Justice. Thank you, sir.
Thank you, Professor. You may step down. All right, Mr. Hammond, you as the prosecutor now have the opportunity to make your closing statement.
Thank you, Mr. Chief Justice. May it please this tribunal, I have but a few observations to share with you. As in all cases, there may be things upon which we can all agree. Possibly we could all agree that the objectives of the president were noble. After all, this is a president who fought to free 3 million slaves. This is a president, as we heard, who risked all to secure peace through victory. Possibly we could start from the common foundation that those indeed are noble objectives. But the issue is not with the objectives. The issue is with the choice of the means to achieve those objectives. We now know from the testimony you've heard that the means chosen here by the president included suspending the writ of habeus corpus, both on his own and after 1863, when he had some authority from the Congress of the United States, he continued to do so in a way not in conformance with the will of Congress. We also know that armed with the power of the suspension of the privilege of habeus corpus, he and those who acted at his direction denied to citizens in this country the most basic rights under our Constitution. Freedom of speech and press was directly curtailed in a way that most of us, I hope, would regard as unthinkable. People arrested because they said such odious things as, "I oppose the draft." Hooray for others who oppose the draft. For that, summarily, men were sent to jail. Men were sent to jail without a trial, without the speedy and public trial afforded by our Constitution. They were sent there while the civil courts were open. They were afforded no trial of any kind before a jury, only before military tribunals created by this administration. They were not afforded the opportunity to confront their accusers, nor were they given the rights of counsel afforded under the Constitution and under the Fifth and Sixth Amendments. We have heard that this must in some way be justified because no one complained. Well, I would ask you to think about what the Constitution tells us. On this, we submit that the Constitution is absolutely clear. The President's obligation is not simply an obligation to do the things that will be tolerated by a coordinate branch. The President has, as has every president had from the founding of this republic, a duty to take care that the laws be faithfully executed. It is a heavy burden, and it is a burden he bears alone. The Constitution gives him the entitlement to seek the opinion of the heads of other departments. He did that, he received an opinion, and he ignored it. We do have an opinion by a court, by the Chief Justice of the United States. At no point did this president look at that opinion and say, here is why I disagree with it. There was never a debate, there was never a discussion. There was just the ex cathedra decision by this president that he was going to do what he had set out to do. We submit, ladies and gentlemen of this Senate, that when the President took the oath of office, which appears in these precise words in the Constitution, I will faithfully execute the office of the President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. He took on a serious, maybe the most serious obligation any human being in this century has yet incurred. But it is not acceptable, we submit, to say we had big problems. We had problems that required us to do things that we think would preserve the Union. He had guidance, and that guidance came from our Constitution. It came from the Founding Fathers. It came from people who said, you can manage this country through the most difficult crises with a First Amendment. You can survive with free speech. You can survive with jury trials. The fact that the President thought otherwise, we submit to you, is the worst form and the most blatant form of obstruction of justice. And it is precisely that obstruction of the courts, that obstruction of the process that should be afforded to us all, the due process of law, is the very thing that must result in the finding by this tribunal that this gentleman engaged in what can only be described as a high crime. Thank you, Mr. Chief Justice.
Thank you, Mr. Hammond. Mr. Mauet, as counsel for the defendant, you may make your closing statement.
Thank you, Your Honor. Members of the Senate, this is a case about law, and it's a case about politics, and a case about history. And we already know what history will say about these 4 years. History, we know, will say that Lincoln, the president, saved this union. That his first obligation was to protect the Constitution of the United States by protecting this country from being destroyed. And he succeeded. And we know that history will accord him the status of a hero along the likes of Washington and Jefferson and the Founding Fathers. That's what history will say. But you know, there are people in this Congress, in the House, with other thoughts. There are radicals in the House with a different mission, who believe that now that the war is over, now that we no longer need the commander-in-chief to lead, now we can go about business as usual. And they want to tear the president down. Why? Not because of the law, because of politics. But we know one thing, that history will know it, history will remember it, and history will judge it, because history always does. We said it's a case about law. In March of 1861, President Lincoln had the biggest catastrophe on his hands from the moment of his swearing in that any president in the history of this country has ever faced. Baltimore was burning, rail bridges were being destroyed, draft resistors were abounding, anti-union agitation was strong, and the president suspended the writ of habeus corpus on behalf of Congress that was not present, and he expressed confidence in a message to Congress shortly afterwards that when Congress had a chance to convene and be in session, they would surely approve of his acting on their behalf when they were absent. And Congress never disapproved. And for 2 years, the military situation went from precarious to worse, back to precarious. And for 7 times, the president suspended the writ of habeas corpus in conjunction with military concerns, protecting railroads, protecting telegraph lines, keeping draft resistors and draft riots from disrupting the defense of this country, all things done in service of his highest duty to protect and save this country and the Constitution, that is, our laws. For 2 years, Congress never did anything to suggest that they disapproved, they found it improper. But then things changed. The Gettysburg battle occurred. The New York City draft riots in March of '63 occurred, and things started to get better. And Congress enacted its own statute, as the prosecution has pointed out time and time again. But you know what? They told you about provisions of that statute, but they failed to tell you the most important one. The most important provision in that statute, which shows you that the president, as a matter of law, cannot have been guilty of a high crime or misdemeanor. When Congress enacted that statute on March 3rd, 1863, part of that statute was Section 4. The prosecution didn't want to read that to you, and I suggest after you hear it, you will know why. It is not in part of your materials. That statute says, Section 4, and be it further enacted that any order of the President or under his authority made at any time during the existence of the present rebellion shall be a defense in all courts to any action or prosecution, civil or criminal, pending or to be commenced for any arrest or imprisonment made under and by virtue of such order. That statute, which you passed barely 2.5 years ago, confers absolute protection in civil and criminal courts to any acts carried out pursuant to Congress's statute of March 3rd, 1863. And the question you have to ask, the question they don't want asked, but we have to ask is, if the only 4 articles of impeachment deal with the president's suspension of the writ of habeus corpus, and Congress's own act 2.5 years ago bars any civil or criminal consequences from it to anyone, including the president, how then, even assuming all these facts are true, can the president be guilty of a high crime or misdemeanor if the statute says you cannot be? Well, I said this is a case not just about history or law, it's also a case about politics. Because politics explains why we're here. When the House voted the articles of impeachment, they knew the statute they had passed 2 years earlier. They knew that statute barred any criminal prosecution of anyone acting under the color of Congress's suspension or earlier time. They knew the president could not be guilty of a high crime or misdemeanor because Congress itself had made that impossible. And yet the House still voted the articles of impeachment. Why did that happen? The only explanation is politics. As Professor Foner reminded us, things changed. And they changed in 1864. And now that the country looked as though it was progressing satisfactorily toward winning the war, now those elements in the House decided to take matters in their own hand and get rid of a president who looked as though he may not be aggressive enough in dealing with the defeated South when that event occurred. And already in 1864, there were elements trying to undo the president by running John C. Fremont against him, and that attempt failed. Fortunately, the events of last April, when the president barely survived assassination, from which he's still recovering, That attempt failed. And now we get down to impeachment as the last recourse to eliminate a president who seems set on having reason and moderation and compromise dictate how we will reunite this country after this war of rebellion. And because those elements in the House do not want compromise, do not want the voice of reason, do not want moderation and compromise, we are here attempting to impeach a president for high crimes and misdemeanors which this Congress has already said the president is not to answer for either civilly or criminally. The only explanation of why we're here is not because it's law, it's because it's politics. So then we come back to what I said in the beginning. Ultimately, it's a question about history. Because history always learns, and history always remembers, and history always judges. And the question you have to ask yourself is, as members of the Senate, in this matter, how do you want history to record you? Thank you, Mr. Chief Justice.
Mr. Prosecutor, before we started these proceedings, we agreed that you would be given the choice of which, if not all, of the articles of impeachment would be submitted to the Senate for a vote. Have you chosen?
Yes, Mr. Chief Justice, we believe that all 4 articles should be presented, and we are comfortable in their presentment in the order in which they appear.
Do you wish them collectively or individually voted upon?
I have just a moment. Do you want to, shall we just have them do one vote? We think under the circumstances, since a verdict on any one would spell the end of this presidency, we just as soon do them all at one time.
All right, thank you, sir. Now, ladies and gentlemen of the Senate, you have before you all 4 of the articles of impeachment which were to be proven today before you by the evidence and under the law. And I'm going to now describe to you your duties. Members of the Senate, Article 1, Section 3 of the Constitution of the United States provides that no person shall be convicted without the concurrence of 2/3 of the members present. That refers to the members of the Senate that are present, and you are the Senate. In accordance with the rules adopted by the Senate for this trial, you have heard all the evidence that will be presented, and the time is now for the senators present to vote on the articles of impeachment. And because the parties have agreed that if the president is found convicted of any one of those articles of impeachment, then that will be sufficient for conviction. So now at this time, you will not be given time to deliberate and think or discuss. You are going to have to register your vote. And if 2/3 of you vote for conviction, of course, the president will stand convicted of the impeachment. And so now I will ask those of you who wish to vote for conviction to stand. If you wish to vote for conviction, stand. Any one of the 4. Any one of the 4 constitutes a conviction. Notice most of the law professors. All right, thank you very much. It's obvious from the polling of the Senate that the conviction is not confirmed, and that a judgment of not guilty should be entered in the trial of the impeachment of President Abraham Lincoln. I wish to thank counsel and the witnesses for an excellent presentation. I'm sure we'll... And and I just hope that their fees are not paid in Confederate money. The Senate is now adjourned, and the reception is to be held in the first floor lobby.